Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court judgment pronounced now in the area of civil procedure, especially matters involving a civil court has jurisdiction to try a suit filed by a borrower against a bank or financial institution. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Bank of Rajasthan Limited versus VCK Shares and Stock Broking Services Limited, pronounced on 10th November 2022, the appellant bank sanctioned a term loan to the respondent company. By mutual agreement, a further credit overdraft facility was granted. The respondent did not adhere to financial discipline, resulting in appellant issuing a notice calling upon the respondent to settle the term loan account and overdraft facility account. Failure to make payment led appellant to seek a recovery certificate against the respondent. The respondent also filed civil suit before the Kolkata High Court, claiming a decree for sale of the pledged shares, a recovery of sale proceeds, and an inquiry into the losses suffered by the respondent, along with a decree for payment of money after the same. When the appellant sold the pledged shares to adjust the amounts against the dues in view of the authorization available with them as a part of the loan transaction, the respondent filed civil suit before the Kolkata High Court. Appellant filed applications seeking rejection of the plaint and dismissal of the suits filed by the respondent on ground of lack of jurisdiction. The single judge allowed both applications and directed the suits to be taken off from the file of the High Court. The appeals filed challenging single judge order came to be allowed by the division bench. Being aggrieved, the present appeals have been filed. The Supreme Court has held that Section 17 of the Recovery of Debts Due to Banks and Financial Institutions Act 1993 bars the jurisdiction of the civil court only in respect of applications filed by the bank or financial institution, whereas did not bar the jurisdiction of civil court to try a suit filed by the borrower. There was also an absence of provisions in the Act for transfer of suits and proceedings, except Section 31, which relates to pending suit proceedings by a bank or financial institution for recovery of debt. The significant aspect of Section 17 and 18 of the RDB Act was that even after establishment of the DRT, no jurisdiction was conferred on it to try independent suits or proceedings initiated by the borrower or others against banks or financial institutions. Only a cross action in the form of a counterclaim by a defendant is permitted in the pending application to facilitate a unified proceeding. A counterclaim in the bank's application before the DRT was not the only remedy, but an option available to the defendant borrower. The borrower was not precluded from filing a separate suit or proceeding before a civil court or other appropriate forum. Not only that, even the bank in whose application a counterclaim is made has the option to apply to the DRT to exclude the counterclaim of the defendant while considering his application. If the DRT were to find in the bank's favor, the defendant would have to approach the civil court in respect of such excluded counterclaim, as the DRT does not have jurisdiction to try an independent claim against the bank or the financial institution. Thus, there are no restrictions on the power of a civil court under Section 9 of the Code unless expressly or impliedly excluded. Further, a summary remedy is provided in respect of claims of banks and financial institutions so that recovery of the same may not be impeded by the elaborate procedure of the court. The defendant has a right to defend the claim and file a counterclaim in view of subsections 6 and 8 of Section 19 of the RDB Act. In case of pending proceedings to be transferred to the DRT, Section 31 of the RDB Act took care of the issue of mere transfer of the bank's claim, albeit without transfer of the counterclaim. Thus, if the debtor desires to institute a counterclaim, that can be filed before the DRT and will be tried along with the case. However, it is subject to a caveat that a bank may move for segregation of that counterclaim to be relegated to a proceeding before a civil court under Section 1911 of the RDB Act, though such determination is to take place among with the determination of the claim for recovery of debt. Thus, there is no provision by which the remedy of a civil suit by a defendant in a claim by the bank is ousted, but it is the matter of choice of that defendant. Such a defendant may file a counterclaim or may be desirous of availing of most strenuous procedure established under the code, and that is a choice which he takes with the consequences thereof. The legislature did not at any stage make any further amendment for excluding the jurisdiction of the civil court in respect of a claim of a defendant in such a proceeding being filed along with the suit. For the issue of the power of the civil court to transfer an independent proceeding instituted by a defendant to be tried alongside a recovery proceeding before the DRT, there is no specific power to transfer a suit to the DRT. A plaint can be returned only under the provisions of Order 7, Rule 10 of the Code for the reasons specified therein. In the absence of such reasons, Section 151 of the Code cannot be utilized as a residuary power to achieve the transfer, which is really a consequence of return of the plaint when the grounds under Order 7, Rule 10 of the Code are not satisfied. The absence of any legislative power cannot give a power by implication to the civil court. It would not be appropriate to read such power to transfer a suit to a DRT under Section 151 of the Code when the DRT is a creature of a statute and that statute does not provide for such eventuality. Even where a defendant is to invoke the jurisdiction of the DRT by filing a counterclaim, the bank has the right to seek a relegation of that claim to the civil court, and the DRT has been empowered to do so, albeit at the final adjudication stage. This is so in view of the summary nature of the remedy provided before the DRT, and thus if certain inquiries beyond the contours of what the DRT does are envisaged, a civil court remedy may be considered as appropriate. Once there is no power of transfer in the civil court, the consent or absence of it is not something which would lend such power to the civil court. The option before the defendant who has instituted the suit is clear. Either he could file a counterclaim before the DRT or he could institute separate civil proceedings. It is not open to a defendant who may have taken a recourse to the civil court to seek a stay on the decision of the DRT awaiting the verdict of his suit before the civil court, as it is a matter of his choice. In case of such an option exercised by the defendant who filed an independent suit, the claim petition under the RDP Act would continue to proceed expeditiously in terms of the procedure established therein to come to a conclusion whether a debt is due to a bank and or financial institution, and whether a recovery certificate ought to be issued in that behalf. The fact in the present case is that the proceedings under the RDP Act have reached a culmination with satisfaction of the claim, and thus no proceedings instituted by the appellant are pending before the DRT. As for the suit, there is no question of a counterclaim or a transfer or any other manner other than trial of the suit instituted by the respondent. In fact, some part of the claim of the bank was not even allowed and some adjustments were directed to be made. Even thereafter, so far as any other claims of the respondent are concerned, the DRT permitted the respondent to pursue the remedy in accordance with law, which can only mean the civil proceedings. Thus, the suit is liable to proceed accordingly. Further, the judgments in United Bank of India, Calcutta versus Abjit Tea Company Private Limited and others, reported in 2007, SCC 357, and State Bank of India versus Ranjan Chemicals Limited and another, reported in 2007, 1 SCC 97, are held not to be laying down the correct legal proposition. The judgments in Indian Bank versus ABS Marine Products Private Limited reported in 2006-5 SCC 72 and Nagar Industrial Enterprises Limited versus Hong Kong and Shanghai Banking Corporation reported in 2009-8 SCC 646 are affirmed except to the extent that they allow the transfer of a suit from the civil court to the DRT.